in the Huawei appeals.
And Mr. Howard, you and the other members of the bar can take it that we have read all the written cases and the judgments below.
Would Your Lordship like me to introduce the counsel?
I don't think that's necessary.
The central question in these appeals is whether the English court can and should grant an injunction restraining infringement of UK patents, which the owner has agreed to license to the world on fair, reasonable and non-discriminatory FRAND terms, unless disputed foreign patents are licensed and licensed on terms set by the English court, which effectively require a compromise of foreign rights and paying worldwide royalties without adjudication of liability, without reference to how the foreign court with jurisdiction over the foreign patents would decide, and indeed irrespective of the foreign court's decision. As your lordships know, the question arises against the background of ETSI, an industry body which adopts wireless communication standards that everybody in the mobile phone industry must use to access markets all over the world. ETSI expects its members to declare patents they have, which may be essential for use in a given country of ETSI standards, in the sense of necessarily infringed by such use, and to undertake to license such patents to the extent that they actually are essential and thus actually are infringed by everyone who uses the standards, and they're to do so on FRAND terms. Now, in our submission, indeed, to some extent, I think this is common ground, the effect of the undertaking is to relinquish the normal monopoly right, the right of exclusion, and consequently the right to injunct breach for patent of a country which actually is an essential patent in return for a license fee for that essential patent. The effect of this is that everyone can therefore use the standards and participate in the market in any particular country on payment of a license fee for the essential patent they are thereby necessarily infringing. It's important to note that just because a patent has been declared to ETSI as a patent which may be essential does not mean it actually is essential. The declaration is an exercise of self-certification and it is not checked by ETSI in any way. Not only may the patent not in fact read onto the standard, correctly interpreted in accordance with its governing law, but critically, a very substantial proportion of declared patents are invalid under the laws of their country of grant. A declared patent of any given country is therefore a patent which users of ETSI standards might not be infringing at all, and in respect of which the owner might in fact not have any exclusory right and not be entitled to a license fee. The owner of a declared patent of a given country in the normal course has to establish that its patent is actually necessarily infringed by the use of ETSI standards in that country in order to be entitled to be paid a royalty. A core issue in these cases, therefore, is whether the courts below were right to conclude that having established that a single declared UK patent is a valid and essential patent, which is necessarily infringed by the use of ETSI standards in the UK, it is appropriate for the English court to require, as the price of avoidance of an injunction restraining infringement of that UK essential patent, that the implementer should license the patent owner's entire portfolio of declared patents worldwide, whether or not valid, essential, and infringed in their respective country of grant. Now, on the face of it, we suggest there is something surprising about that conclusion. If you have a declared patent, for instance, in China, you could not recover a royalty or license fee for that declared patent in the Chinese courts without actually establishing that that patent was essential and thus necessarily infringed by the use of standards in China. Why should the fact that you may show you have an essential patent in the United Kingdom entitle you to demand a license fee for your declared patents in China as the price for avoiding a UK injunction in respect of the UK essential SEP? And it does not matter for this purpose whether one is referencing a Chinese patent or a US one or a Korean one or indeed German, Spanish, Italian ones. The same point applies. Yet, this surprising conclusion is the effect of the decisions below. The respondents in these cases are intellectual property licensing companies. They, as a result of ETSI, have agreed to license their patents for royalty income. They each own a multinational portfolio of declared patents, that's to say patents of different countries which have been declared to ETSI as patents which may be essential for the use of the standards adopted by ETSI. Such declarations, in fact, took place originally by Nokia and Ericsson, well-known mobile telecommunications company, from whom the respondents have acquired their patents. That acquisition has been part of a, we would say a ploy, but a policy in any event, by Nokia and Ericsson to seek to gain additional revenue in the light of their declining role in particularly mobile phones. The respondents agreed to license these declared patents if they are essential in the sense that I have described. Now, as your lordships will have seen, they sue in this country, firstly for a declaration that a small number of declared UK patents are essential for the use of ETSI standards. Now, it's important to note that it is recognised that before the, I'm using the expression UK, but of course the action's before the English High Court. And they recognised before the English High Court they had to establish, because it was in dispute, that the patents that were the subject of the suit were indeed essential and infringed, and that required, in the light of the disputes that had arisen, proving that they were indeed valid and essential. And so they seek a declaration that Huawei is infringing their UK patents by using ETSI standards in the UK by importing and selling mobile phones. At the moment, I'm not drawing a distinction between Huawei UK and Huawei China. And then they seek damages or an account of profits for infringement of those UK essential patents. So far, so good. Then they seek a declaration that FRAND terms for the license of these UK essential patents are a global license that they have offered to their multinational portfolio of declared patents, and thereby seeking worldwide royalties. And then they seek their injunction restraining infringement of the UK essential patents unless the terms of such global license is agreed. So the effect of the injunction that was ordered by Mr. Justice Burse in the Unwired Planet case, and which Conversant seek to replicate, is to make the price of participation in the UK market the licensing of the global portfolio of declared patents of foreign countries, whether or not, as I've previously said, and I'll explain, whether or not they're valid, essential, or even infringed. Now, it is interesting to see how the genesis of this, and to see what Mr. Justice Burse's reaction was when such a claim first came before him in a case called Viringo. There, we suggest he was clearly of the view that what was sought to be done, and what he ultimately did, would be wrong and indeed very surprising. The first Viringo decision is in the authorities at A10, tab 190, MS, page 11336. This was an interlocutory decision concerning the manner in which the case should be tried. And if you go to, I'm not going to obviously take time reading large parts out, but you can see at paragraph 4 that, or paragraph 2, you can see that the action concerned, there were 2 actions, Ringo against ZTE, for infringement of 6 patents, 3 in each action.
I'm sorry, which page are you
I'm
on?
sorry, my lord, it's 11329 in the
Yeah.
I thought you said
MS
11336, 11329.
yes, sorry, did I give you a false reference?
Yeah.
Thank you.
That's the beginning of the judgment.
Yes.
And paragraph 3, he explains the standards. Paragraph 4, he explains Vringo offering the global portfolio license and its argument that it was frowned. And what he then, if we go forward, if you go to page 1133, what was being suggested in that case was that the court could proceed to a FRAND determination, hold a FRAND trial, absent any findings of invalidity. And so you could just go straight to that as a matter of practicality. And that's the context in which he was considering this. So you see at paragraph 36, he refers to what he calls a second kind of case, and where the court determines the rate which would be arrived at as the outcome of a notional negotiation between willing licensor and licensee without willing to negotiate without fighting a trial on the merits about the underlying rights. Now, just stopping there for a moment, that what he's describing there is actually very, very important in relation to matters we'll come on to. Where you have, say, 2 global telecommunications companies, or a licensor with global patents all over the world, and a potential licensor with businesses all over the world, you could have a commercial negotiation which involves a compromise of rights. And so you don't ever have a trial on the underlying merits. But as the judge goes on to explain, you could have a trial before the court which assessed that outcome by agreement. And that's the point he makes first in paragraph 44, where he says, case is a long way from having to consider whether to grant injunctive relief. After all, according to ZTE, the patents are all invalid and not infringed. However, in any case, I reject the idea that the stance being taken by ZTE in this jurisdiction can fairly be said to mean it's not a willing licensee. ZTE said it's willing to take a FRAND license on any patent found valid and infringed. In my judgment, a defendant accused of patent infringement by a patentee who claims to have a standard similar patent is and must be entitled to say, I wish to know if this patent is valid or infringed or not before I take a license. Such a stance can't be fairly described as unwillingness. And then he goes on to say in 45, so here the defendant is entitled to adopt a contingent position. In a contingent case like this, there's no basis on which the court could compel the defendants to accept a license arrived at by approaching the matter as if the licensee was willing to take a license without having a judicial determination of validity or infringement. Now, of course, just stopping there for a moment, one would have said that's utterly obvious in any case, that the court can't require people to take licenses of rights which may not exist. But as I'll show you, that is precisely where we have got to, and that is actually the position that my friends are pushing. And if we then go forward to paragraph 55, he explains that the court cannot and should not seek to compel or coerce a defendant into that position. That's the position of taking a license in respect of disputed patents. The defendant in this case is entitled to challenge validity and infringement of the patents in suit.
The patents in suit were were UK patents.
They were. But the point he's making applies equally to foreign patents, which you're saying should be the subject of the license. Can't make any difference that we would suggest that the patent owner claims to have, for instance, to make it in simple terms, he has one UK patent and one USA patent, and to say, well, I've proved I've got the UK one, and you must license the US one, which is actually in dispute, and the English court can't determine that, because the question of validity of the patent is a matter for the US court.
But as I understand, I mean, I've only just looked at this
Yeah.
case for the first time, but it rather looks as though ZTE were asking that there be a trial of the validity of the 6 UK patents, whereas Vringo were asking the court to go directly to determine the terms of a FRAND license.
Yes.
Yes.
The point that the judge was making is that it wouldn't be of any utility, because to determine the FRAND license where ZTE firstly put things in dispute, but he was also making the point you couldn't coerce ZTE into taking a license of foreign patents whose validity was in dispute. That was the point that was being discussed in paragraph 54. And you'll see 54 was about 54 is making the point that if the parties agree that the court should decide the terms of a global license and they're not going to dispute validity, then that would be effective. But 55, the point he's making, is that you can't do that where they're challenging validity and infringement of the patents in suit. 56, and you see in the last sentence, you can't alter the character of the underlying rights. And you'll see he comes back to this in what is called Veringo 2, which is it's in A4 at tab 73. MS 6355.
Sorry, can you give me that number again?
Yes, the judgment starts, my lord, it's MS 6355. The relevant page that I want to go to is at page 6374. Look at 103. You'll see the argument that was being put forward was the same thing that one ultimately finds in these cases. 103, second line, that Veringo has offered ZT a license under its patents. The license is global, and ZT hasn't accepted. It doesn't want it. It's prepared to take a FRAND license under any patent which is truly a valid SEP. And then the last line, penultimate line, ZT said Veringo wants to impose the global license. And at 105, he explains how Veringo put its argument as to a global license. And you see his argument that it's the kind of thing which the industry enters into. And at 106, he says he's skeptical about the argument and dealing with a abuse of dominant position argument. And at 107, second sentence, I suspect the fallacy in the reasoning of Veringo at this stage may be just because it may be so that the global portfolio offer is a FRAND offer, it does not follow that the global portfolio license on offer is the only set of terms which could be FRAND. Seems to me there's likely to be a FRAND rate for the particular UK patent that he'd found. I can see that the aggregate of individual FRAND rates for patents taken alone and on a territorial basis may well be far more than the global portfolio rates, and so a rational defendant may well prefer to take a global portfolio license rather than a series of individual ones. Just stopping there for a moment, that's just talking about the economies of scale, not any legal principle. But he then goes on, moreover, I accept, as Ringo urges on me, global portfolio licenses are the kind of licenses industry normally enters into. However, this is very different from saying that somehow the fact a global license on a portfolio of patents is frowned necessarily means that a defendant in one jurisdiction faced with one patent is forced to take a global portfolio license in order to stave off a national injunction on that one patent. I could see a very different circumstance if Varango had made a frowned offer for the UK patent itself, and that offer had not been accepted. Then an injunction might well follow. In that sort of case, unlike the one based on the global portfolio license, the threat of the injunction, which is after all a territorial remedy, would not being used to create some sort of international coercion or coercion about other patent rights. In our submission, that is he was entirely right there. And then he notes at 1110 there may be all other kinds of issues at play. Perhaps the court should consider damages in lieu of an injunction. That's a point that we come on to. So at that point, Mr. Justice Burse took the view that a variety of license offers might be possible. The implementer would not be subject to some sort of international coercion or coercion about patent rights through threat of an injunction, and that if the patent owner sought to do this, damages in lieu might well be the appropriate remedy. Now, in the Unwired case, at a preliminary stage, we don't need to turn it up, I'll just give you the reference, A3, tab 66, MS 6129, paragraph 27, he appeared to remain of that view. He, in fact, expressly said he did. But at trial, he changed his mind. Now, don't say that a judge isn't entitled to change his mind, but I do say that Mr. Justice Burse's first, second, and indeed third thoughts were correct. Now, as you will see, the effect of the approach that the patent judges have taken to these claims is effectively to set up this jurisdiction as a de facto international or worldwide licensing tribunal for the telecommunications industry, and a place portfolio owners can come to obtain payment for their declared patents worldwide without having to show that those patents are being infringed. Now, let me just make good that point by looking at what Mr. Justice Burse has done in the Unwired case. So he found that Unwired Planet had two UK SEPs. The numbers don't matter, but there were two. So two standard essential SEPs, patents. Because those UK patents were found to be SEPs, that's to say patents necessarily used and infringed by anyone selling phones or infrastructure equipment in the UK, and it's important everybody understands this infrastructure is just as important, particularly to Huawei. There was a breach of the patent. In other words, there was a tort in the UK. He assessed damages for breach of the UK patents on the basis of the royalty rate that would have been payable for those patents. And that was limited to a royalty on UK sales, or, if you like, a UK royalty. Now, stopping there, that was entirely conventional and unobjectionable. But he issued a final injunction against Huawei, restraining infringement of those two UK patents unless it entered into what he called the settled global license, and it's the scope and terms of that which are objectionable. As I've already said, the effect of that would be to prevent Huawei selling mobile phones or infrastructure in the UK unless it entered into that license. In other words, that license for Huawei is the price of participation in the UK market, and that license, that form of license, will for the future be the price of participation for any telecommunications company in the UK market. Now, the courts below were motivated by two factors in adopting this approach, and Mr. Justice Burse in changing tack from what we've seen in Viringo. First, what was referred to as the administrative efficiency of licensing on a global rather than a country-by-country level. Mr. Justice Burse described country-by-country licensing as madness, and we'll come back to that. The basis for that is that he said that willing licensors and willing licensees of global portfolios, like Unwired, when applied to a multinational company like Huawei, would agree on a global license because it would be, in his words, far more efficient. They might agree different rates for different countries, but they would not embark on country-by-country licensing. So that was very much Mr. Justice Burse's approach. In the Court of Appeal, they focused in particular on the need to enforce patents on a country-by-country basis and the prohibitive cost, as they saw it, of doing so. That was the factor which you will see in paragraphs 58 and 111 of the judgment, which we will come to. And Lord Justice Floyd, in another case, described paragraph 58 as being the rationale of the decision. So it's a very important paragraph. And the Court of Appeal said it would be unreasonable for a global user of ETSI standards, on having been found to infringe a valid and essential patent in a given country, here England, to expect the patent owner to sue in each country in which it had declared patents and family members to enforce those patents on a country-by-country basis, in order to claim the payments to which the Court of Appeal considered it was, and I use the word they used, entitled. And that, as your lordships will, I think, understand, shows immediately the flaw in the reasoning, the word entitled. Because the Court of Appeal effectively held that having been found to infringe one essential patent, it was unreasonable not to license the patent owner's entire global portfolio because somehow the owner is entitled to remuneration in respect of those declared patents.
And why do you say the word entitled is a mistake?
Why do I say what?
The word entitled is a mistake.
Because it's assuming that you can only say they're entitled if the patents are in fact, the foreign patents are in fact SEPs. A matter which the court hadn't determined and wasn't able to determine. You have no entitlement to to exclude, for instance, in China, there is no entitlement to exclude Huawei from using a declared SEP if it isn't in fact a SEP, and there's no right to a royalty.
That will be true, but I thought that Mr. Justice Burse relied upon evidence as to the way in which commercial negotiations were in fact handled between implementers and owners of bundles of patents. And in effect, as I understood the evidence and his findings in the light of that evidence, whilst what you say is true as a matter of law, it would be prohibitively expensive to have trials, country after country, to test essentiality, validity and infringement. And people do a sort of fairly rough and ready assessment between themselves and end up counting.
Counting is counting of what are actually SEPs. You need to be careful about confusing different things. So the way in which the licenses are, or one way of calculating a license, is not the only way, or a royalty, is to work out what's been called the top-down method, where you calculate the total number of SEPs that are actually in existence, say in China, then you work out...
And I'm so sorry to interrupt. When you say SEPs, are those the self-declared SEPs at that point?
No, those are real SEPs, real ones.
So does the counting method only work then after you've had trials in all the regions?
Well, the counting method only works if you take the first stage your Lordship was asking about. There are hundreds of thousands of declared SEPs, literally. Nobody treats the declared SEPs as anything other than a starting point to work out how many actual SEPs there are. And your Lordships will have seen in the papers that Mr. Justice Burse had one view, another view in one of the American decisions, and then I'm going to go to the Chinese decision where they have found, I can't remember the exact number, but something over 2,000 in China. It's a fraction of the number that are declared. And then the second stage in the top-down method is calculating how many SEPs the patent owner actually has. But going back to your Lordship's first point, if parties don't wish to litigate and they wish to compromise, then as with any disputed position, you may reach a view, you reach a settlement. And that happens every day in relation to disputes. Indeed, most disputes are settled. But of course, that is rather different, we suggest, from the position where the parties don't agree and then there is a dispute which the court has to resolve. At that stage, the court has to decide, well, actually, what rights do you have? That's, in our submission, what Mr. Justice Burse was recognising in the first Baringo case. But if we just go back to the court, I think my Lord Reid wanted to look at paragraph 58.
I was looking at 58.
Yes.
It's on page 498. Just wondering where what you say is the misuse of entitled occurs.
The Court of Appeal...
111, the misuse of entitled.
I'm sorry.
Were you talking about 111?
I said 58 and 11.
But the misuse, your alleged misuse of entitled is in 111?
And in 58.
Right.
It's in both. It's both places. But you'll see in 58,
was an entitlement to the usual relief.
Yes.
Which is
What you are criticising is 111 at the end, I think.
yes,
Yes.
well, in 58, I mean, the point I was referring to, you'll see the Court of Appeal in 58, in the middle of it says, were the position otherwise, the SEP owner seeking to recover the FRAND licenses for all of the SEPs in the same family from an uncooperative implementer who's acting unreasonably would be required to bring proceedings in every jurisdiction in which those rights subsist. Now that's assuming that the rights in fact do subsist. And there are 2 points you should note about that. Firstly, a patent that's in the same family is in fact just in a different jurisdiction is just a separate patent. The fact that it's found valid in the United Kingdom doesn't tell you anything about its validity in China. But in fact, the portfolios of patents that are sought to be licensed are not just ones in the same family. And at 111...
You read 111, I mean, there are 2 places where they refer to it. One in the sentence, the patentee must then bring proceedings country by country, halfway down, and then it comes back at the end. But reading the paragraph as a whole, the Court of Appeal's obviously aware that entitlement to an injunction will in fact depend upon proof of validity and infringement.
Well, but only in the United Kingdom.
Well,
It's the only thing you have to prove on the Court of Appeal's approach and Mr. Justice Burse's approach, my lord, is validity and infringement of a UK set.
I understand that. I'm simply suggesting that the Court of Appeal is not mistakenly thinking that there's an entitlement to royalty in every country, regardless whether in that country, I'm not talking about the UK, every other country, regardless whether the patent is valid and infringed in that country.
Well,
I can see how if you take the two sentences out of context, you might think that, but I'm not sure that's the right way to read the
my lord,
paragraph
if
as
you
a
go to
whole.
111,
I'm there.
the
Yes.
sentence where they say the patentee must then bring proceedings
Yes.
country by country to secure the payment of the royalties to which it is entitled,
Yes.
that is saying that it's unreasonable that you have to do that.
Yes. But it's not making any assumption of an entitlement to royalties.
Well, it is because the result of what they're doing is saying that you shouldn't have to sue to recover what to prove your entitlement. And so you can set a license. It's important we see the terms of the license. You can set a license for these foreign patents, because that's actually what is happening, even though you haven't established. Now, of course, the terms, one can say that the English court here is not making a determination that there is infringement and you must pay, because it can't do that, but it is saying, for the purposes of your having access to the UK market, you will be injuncted from breaching the UK patent unless you pay for these foreign rights, which in my submission, the premise of the discussion is that you have foreign rights, which the court isn't in a position to determine.
Sorry to come back to the question I asked, but I had got the impression from Mr. Justice Burse's trial decision that there were bundles of claimed SEPs, and one of the background factors against which people in the commercial world would negotiate for a global license is that they couldn't be sure which of the SEPs actually were SEPs and which were valid and which were being infringed. But there was a reasonable prospect that some, at least, would be true SEPs, would be valid, would be infringed. And against the background of uncertainty, which ones actually were SEPs, valid and infringed, but the likelihood that there would be some which were true SEPs and valid and infringed, it made sense to, from a commercial point of view, agree global licenses. So that doesn't assume that each and every SEP is valid and is essential and is infringed, just that some in the group are.
That's true. That's what people may do in a commercial sphere, but doesn't answer the question as to whether you require, as a term of an English injunction, that, I mean, for instance, if your position is, I don't accept that any of the patents that a party has are in fact valid, doesn't have any, and that's the position in the conversant case, for instance, you'll see that effectively that is almost, they have lost, conversant have lost in China on nearly all the patents that have been litigated. You'll see there were 15 that have been litigated. One has been found to be essential, but validity hasn't been determined yet, and that's because of the way in which that came forward. So potentially that could be knocked out, and on the Chinese judgment, there's absolutely no right to anything in China. And so the point is, my lord, it may well be that that in many, many cases, companies will think it's not worth having litigation and will seek to do a deal. But you have when the matter comes before the court, in our submission, a different approach should apply. Now, just quickly dealing, before I develop the points and show you something more. The point on administrative efficiency, that in fact is largely dealt with by simply giving, as Mr. Justice Burst did, a higher rate for instance, a UK-only license. So he gave, on his UK-only rates, he doubled the rates because of the administrative efficiency. And the respondents ask why Huawei wants to pay double for country-by-country licensing rather than settle up on a global basis. The answer is that on the facts of these cases, the country that counts is China. And I will show you that the Chinese patents have to be relied on to justify a claim for about 85% of the global sales. You'll see 75% has been spoken about in the papers, but it's actually 85%. The UK accounts for approximately 1% of Huawei's global sales, and royalties for Chinese patents dwarf any discount on the UK royalties. So the idea that testing the portfolio in China is madness in our submission doesn't withstand scrutiny. And as to country-by-country litigation, again, one needs to be careful not to exaggerate the point. Now, of course, if it were possible in intellectual property disputes to consolidate multi-jurisdictional patent litigation in a single forum, that might well be desirable. But there is presently no international court, which can do that. And so it is the case that the exclusive jurisdiction of each country over claims for infringement of its patents where validity is an issue requires country-by-country litigation. And the Court of Appeal's criticism of the implementer for requiring vindication of rights in the country where the rights exist really amounts to a criticism of defendants exercising their right to dispute validity of patents which they're asked to pay for, and of the litigation that follows. But in our submission, there's actually absolutely nothing wrong with disputing validity. Defendants have a right to do so, and it's in accordance with public policy that they should. But the prohibitive cost of country-by-country litigation is somewhat exaggerated in that what happens in normal course and one would expect to happen is litigation takes place in the key markets. So in this case, the key market is undoubtedly China for both Unwired and Conversant. But in other cases, you might find that you had China, the United States, and Korea, or a European country. Now, in our submission, there are four principal reasons why the approach below is wrong. First, where the validity of patents is disputed, those patents are not justiciable in the English court. The English court can't grant damages for their infringement nor set royalties for them. And in our submission, nor can the English court assess whether it is frowned for the defendant to be required to license foreign patents of disputed validity. Second,
I'm sorry. Were you going to expand on that?
I will be, yes.
Yeah,
Just giving you our headline points.
Thank you.
Second, the respondents cannot in any event rely on non-payment for foreign patents to show that damages for their UK patents are an inadequate remedy, because such foreign patents are not protected by an injunction restraining infringement of the UK patents. They're outside the ambit of the relief. The third point we make is that the ETSI undertaking doesn't change anything. Fourthly, we say it's, in any event, inappropriate, disproportionate, and contrary to public policy for the English court to exclude Huawei from the UK market because it's not willing to agree a global license set or approved by the English court given that the Chinese patents in the portfolio are overwhelmingly the most important. And the Chinese courts, in fact, provide a single forum where the issues can be adjudicated upon. Now, can I, before developing these points, just consider this? Although China is central to these specific disputes, the points at issue in this case are not simply about China. All the points made in respect of Huawei in China could be made equally well with respect to the United States or anywhere else. As Apple has pointed out in its interveners case, the acts of the English court in this respect would affect them in the United States just as much as Huawei in China or Samsung in Seoul if they hadn't settled. Indeed, one of Apple's points is precisely that Unwired Planet is trying to use one of the patents in the UK as a basis for obtaining a global license which would affect Apple's rights in the United States, and that the value of this on Unwired Planet's case runs into the billions of dollars. We particularly commend their brief to you. But in this case, both of Huawei and ZTE have their primary business in China, and so the centrality of China comes from that. Now, the respondents accept that unless the patent owner has patents in every country in the world, and they don't, the only patents that can potentially justify royalties on sales wherever they occur, that's to say worldwide royalties, are patents of the country of manufacture, that's to say China. And good that point, it's not controversial. If Huawei manufactures the phones in China, let's say 60% of the sales go to countries where there are no patents, then the only patent capable of being infringed is the Chinese patent. But if the sales are all over the world, then what you'd be seeking is infringement of the Chinese patent and damages as the Chinese, under Chinese law for that. Now, patent coverage in China as the place of manufacture is the basis on which Mr. Justice Burst justified worldwide royalties. You see that at paragraphs 540 and 541 of his judgment. But the important point is, if you went to the Chinese court, you couldn't simply say, I've got declared patents in China, and say, therefore, I'm entitled to protection for patent coverage. You'd have to show that your patents were infringed, which would inevitably involve defending a challenge to their validity. Now, therefore, China is in fact the place which is just as a matter of how patents work, is the place that is capable of providing a global royalty or a worldwide royalty if there are valid patents. Now, what is the position in China? The judge in Conversant noted that China accounts for 56% of Huawei's worldwide sales. In fact, that's an average for 3 years, and for 2016 it was slightly higher, 62.4% if we look at 4G. But
do these include infrastructure sales?
No, those are just 4G phones, I think.
But I thought you said a few minutes ago that a very important part of Huawei's business is infrastructure sales.
Because Huawei is, as you, yes, I was just looking at this is just 4G mobile phones. I'm not saying infrastructure isn't important.
I've no idea what proportion of Huawei's turnover is selling handsets rather than selling infrastructure, for example.
I'll check what the position is in the end.
But the 56%, that was also 4G, was it?
I think that's actually worldwide sales. Just
Percentages are meaningless unless you know what they're about. Percentages are meaningless.
unless you know what they are.
Yeah. In conversant law, it's only mobile phones which are alleged to infringe.
We can come back to it.
And sorry, just so I can understand what you've just said, in conversant, when you say only mobiles are alleged to infringe, does that mean there isn't an infrastructure element in that?
I think it may be that the only SEPs that they are putting forward are SEPs that relate to
Manufacture.
mobile phones, rather than, yeah. And the figures I was about to give you are the figures, the 56% figure that Mr. Justice Henry Carr referred to at paragraph 10 are, I think, mobile phones.
Thank you.
The important point, I don't want to get bogged down in the detail because it doesn't matter for the principle, is just focusing on the mobile phones for a moment. Of Huawei's sales, a large proportion take place in countries where there are no patents. So on top of the 56% which are just sold in China, there's another proportion which are sold in countries where the Unwired Planet and Conversant don't claim to have patents. That accounts for 19%. So that you're already up to 75% of the sales. But are purely, you could only get a royalty on 75% if you establish that you have valid Chinese patents. Now, in fact, because of the way Mr. Justice Burse has set the license, the way he's approached it, the figure is higher because the way it works is you get a royalty on Chinese sales, then other markets, but those are just effectively treated as the same as Chinese sales because there are no patents in them, and then a higher rate of royalty for what he refers to as major markets. But the major markets, on Mr. Justice Burse's approach, he only awards a royalty in cases where there is a minimum of a certain number of patents. And so if you adopt that approach and say, well, countries where there are less patents or less claimed patents don't count, you then get to find that actually the sales are only taking place in about 15%, only 15% of the sales are outside of China.
When you just said he only counts major markets if there's a minimum number of patents, you're there talking about the claimed patents, not established after trial as true SEPs.
The way he does it, if we go to paragraph 587 of his judgment,
Page.
Page 757, is that the
MS page 757.
Yeah.
Third sentence, you see, he says, outside China, a Frand approach would be to divide the rest of the world into major markets and other markets by reference to the number of declared SEPs.
Yes, thank you. That was the answer to my question.
Declared SEPs. And what he then does is it's best understood by turning to the license to see how it actually works. And you can pick up if you go to the second volume of the appendix. Sorry, my bundle's got. No, I want to look at the conversant license.
Can I ask you, Mr. Howard, before we look at the license?
Yeah.
I just want to be sure I'm understanding the nature of the argument that you're
Yes.
presenting at the moment. The whole issue of FRAND licenses is raised by Huawei by way of defense. The Unwired seek an injunction and other remedies, and your answer is they're not entitled to one because their entitlement depends on, amongst other things, offering a FRAND license, and they haven't made such an offer to us. Agreed so far?
That's part of it.
Yes. And the entitlement to a FRAND license that you rely on can come from two possible sources. One is the undertaking given by Unwired or their predecessors to Etsy.
Yes.
Enforceable as a matter of French law by a person in the position of Huawei. And the other possible source is EU competition law. Yep. And the judge has heard a great deal of evidence as to what would constitute a FRAND license in the relevant market in the light of the way participants in that market behave. And he's reached certain conclusions as a matter of fact. And you're not really in a position, I think, in this court to challenge the conclusions he reached on issues of fact, but you have to persuade us that he made an error in law, which I suppose, well, I'm wondering what the nature of the error is said to be. It might be, in theory, an error in the construction of the undertaking given to Etsy, although because that's governed by French law, that's itself a matter of fact. Or it could be an error in his understanding of EU competition law. And I'm wondering what the nature of the argument is.
We're not before you making an argument based upon EU competition law. We make our argument centres around English domestic law in circumstances in which a court should grant an injunction. The court has gone wrong in its approach to an English injunction. Part of that argument, and that is, as it were, the central and main issue, But as part of that, Your Lordship was asking me, do we say the approach to ETSI was wrong? Your Lordship is entirely right that ETSI is governed by French law. What we do say is, though, and particularly in the way in which the matter came forward, the issue ultimately was what, if anything, did ETSI have to say about the terms of licensing and how, if there was a dispute, that matter was to be resolved, particularly a dispute about validity. We say ETSI makes it entirely clear that disputes of the type that these cases are concerned with are matters for the national courts. And so that ETSI could not have anticipated and did not intend that in licensing, a patent owner would be entitled to use his undertaking to require, and that a court should then follow that through, to require entry into licenses in respect of disputed patents. Nothing in ETSI upsets the normal position where you are entitled to dispute validity.
Does it all come back, though, ultimately, to what is meant in Clause 6 of the ETSI document by unfair, reasonable and non-discriminatory terms?
Well, the ETSI, that is the way, it comes back to that in part, but you have to, in order to answer that, you have to ask what is the structure of ETSI and what was it intending to look at?
Construing the ETSI document, really.
It's unavoidable that one is, in part of the issues in this case, require construing the ETSI document.
It's a matter of French law.
It is, and there was French law evidence, but in our submission, ultimately on this particular point, you're just, the French lawyers are ultimately just seeing what the document says and deciding what it means. There isn't any, as it were, magical principle which will inform you.
It can't be entirely a matter of English domestic law, can it? Because your entitlement to prevent patent infringement is limited by the undertaking given to ETSI, and also, as it happens, by EU competition law.
Yes, it's the effect of the undertaking you've given to ETSI, leave aside anything else, is that you are not, the purpose of ETSI is that you won't be entitled to exclude people by use of an injunction. And in other words, you are, this is a situation where the owner is agreeing with the world or holding himself out to agree with the world. You can use my patents in return for a reasonable fee. And then against that background, the question is where there is a dispute and the English court is asked to injunct. On what basis does the English court injunct? And we say, even if your lordships were against us on all else, we say that the appropriate response, if we just take this situation where you have established, you have one or two UK SEPs, and let's say you establish more, but there's a dispute about a Chinese portfolio. It's not proportionate for the English court to say, I'm going to injunct in England unless the foreign company based here in China, but it could be based elsewhere, pays a royalty for those disputed Chinese patents. The appropriate thing is to say, all I'm going to deal with are the UK rights. And I do that by saying an injunction's not appropriate and require payment of the same royalty that you've awarded as damages for the past as damages going forward in lieu of the injunction. So, in fact, that would be a coherent response. Can I then go briefly to the license? And I'm taking you to the in CV2 to tab. I got the wrong reference. It's
It's in here if you want it settled.
Yes, we can use it here. I've got, yeah. If we go to tab 11 at page 816 is the license, settled license in the Unwired Planet case.
Is this the settled global license?
It is, yeah. And if you look at one 1.27 on page 21, you see his definition of major markets.
I'm sorry, which page?
Page 821
Thank
in
you.
the MS. And then at 1.28, you can see the major markets, and according to what type of phone, what standard you're on. And for 4G phones, if one were to cross-refer to the countries where there are sales, that's how you get to my figure of 85%. At 128, you see other markets, which mean any country which is not a major market but excludes China. And the royalties you see are set out at 4.2 on pages 823. Royalties at 4.2 for phones and 4.3 for infrastructure. And the effect of it is that the royalty for China is at 4G, for instance, is at 4.2.3, and you can see in the second part of the clause, it's 0.026% of the net selling price in China and other markets. So as I say, that for 4G is in fact 85% of the world. Now, and Conversant have sought to piggyback on the back of this, and the license they seek is essentially a replica of this license, save I think they have upped some of the rates. But the reality is that this license, bearing in mind somewhere between 75% and we say 85% of sales are in China or other markets where there are no patents. The reality is it is essentially a Chinese license. Royalties on 100% of sales are payable solely for Chinese patent coverage, and none of the royalties could properly be payable if the Chinese declared patents are invalid or not infringed, none of the ones for China and other markets, and nor could any of the major markets be valid if the patents were not valid. Now, Mr. Justice Burse recognised, and recognised correctly, that it can't be frowned for foreign sales to be paid on foreign declared patents which are invalid or not infringed. And what is odd about the approach he took is if you go back in his main judgment to paragraph 588, said there that any declared SEP in a country which is determined by a relevant court to be invalid or not essential would cease to count as a declared SEP. So once a foreign court has said a SEP is not valid or essential, then it ceases to count. But that's, of course, prospective. It will have counted for the purposes of the license that was said to be FRAND and failing entry into which an injunction is issued. But the premise of the FRAND determination and the premise of the injunction might have turned out to be false because SEPs were, in fact, no such thing. Now, bearing in mind the centrality of overseas royalties in these kinds of cases, and China in particular in the case before you, it is instructive then to see how this works. Now, there are two significant provisions to draw attention to. I ask you to bear those in mind. The first is the provision for adjustment in the event of Chinese patents or other patents turning out to be invalid or non-essential. And secondly, the terms relating to back royalties. Now, if we go back to page MS 824, clause 4.4, you'll see that adjustments to the list of major markets will be done on an annual basis. Any licensed patent in a country which is determined by a relevant court to be invalid or not essential would cease to count as a licensed patent in that country. So this is the contractual mechanism which Mr. Justice Burse had in mind. But this contractual mechanism does not apply to China. So it is completely irrelevant to the approach that China, which accounts for 85% of the sales on which the royalty is sought, that the patents might turn out to be invalid or essential.
You're reading the words "a country" as impliedly excluding China.
No, because it's the first sentence, my lord. Adjustments to the list of major markets in section 1.2.
And major markets exclude China.
It excludes China.
Yeah.
Oddly. China's the biggest, but it's excluded from the
But that's
definition.
because China had special treatment somewhere along.
I beg your pardon?
That's because China was given special treatment outside these formulaic arrangements, as I understand it.
I follow what you mean.
Well, China wasn't excluded because it wasn't a major market, but because there were other provisions of the global settled license that dealt specifically with China.
China was treated differently because it was recognized that different rates would apply in China.
Yeah.
But as to this point of the effect of the license that's settled is that royalties are payable on Chinese sales, whatever happens in Chinese litigation. However many, if you knock out every single patent in China, it wouldn't matter once you've entered into this license. It won't have any effect.
So you're reading the second sentence and the third sentence, presumably in 4.4, as being restricted to countries which constitute major markets.
The only adjustments are made in major markets, yes. And
I have to say, I wondered whether they weren't intended to apply generally.
Well, the reason that I'm right about that is you have to remember, if you go back to the definition of major market, major market royalty rate is dependent upon whether or not you have a certain number of patents. And so if you establish in a major market, if you knock out patents, then potentially you can fall below the numbers which would mean that country counts. And that's why there is the potential for adjustment. But in China, there's no potential for adjustment. It doesn't make any difference for China whether there are 100 or 1, or indeed we would say none. It certainly doesn't make any difference. Now, you might say this is just a quirk and a mistake of this license, but that is the license that was settled. The more fundamental, insofar as one says, well, either this can't be what he intended, or in any event one could settle another license on different terms, that wouldn't in fact deal with the criticism, which is that this, as it were, amendment is prospective, and only what one is still saying is, this is FRAND at this date, and you've got to pay these royalties today, even though in fact you subsequently establish that they weren't due. There's no mechanism in this for repayment of sums. And that position gets exacerbated, and this is when you look at the position in respect of back damages.
Was this the absence of a retrospective provision for repayment of undue royalties? Was this a matter of argument in the courts below?
In the courts below, in front of Mr. Justice Burse, Huawei's position was he shouldn't be doing this, settling
Yes.
a global license, and he essentially settled it off his own back, and so
Yes, because you didn't. My understanding is you didn't engage in the details of the global
that is
license. Right. Yes, thank you.
Was it taken up in the Court of Appeal? The whole question of rebate.
But the important point is what I want. I'm not, as it were, appealing to here to say because of the way in which this has been done, this court should interfere. I'm trying to make, as it were, an anterior point, but by reference to this, you have a situation where under the license that was settled, there are two oddities about this license. One is that you pay for patents, foreign patents, which might turn out not to be any such thing. And you do that, and you can only get a release prospectively. The court also ordered back damages as the royalty. And under the back damages, we'll see that at clause 3. That a term of the license is not simply that you pay prospectively, but that you pay retrospectively at these rates. And so there's...
Where do we get that from?
That's clause 3.1.
3.1.
3.1.
Sorry. Unlicensed past activities.
Because what you have to pay for, the royalty is from, in this case, in this particular case, is not a royalty going forward. It's not you pay damages for the past and a royalty going forward. You have to pay in order to avoid an injunction from, I think this one is from, yes, the effective date at 1.4 is January 2013. So the royalties have to be paid on this global royalty. So you have to pay a royalty on Chinese disputed patents from 2013.
Is that when Unwired Planet acquired the portfolio?
Yes. In conversant, it's 2011.
The difficulty with the argument, as I see it at the moment, is that the judge arrived at this license on the basis of evidence about how people actually behave in the market. And, if the evidence is that people enter into licensing arrangements for portfolios of patents without knowing which of them are actually valid or not, well, that's the way the market works.
Well, that is the way the market works when people choose not to have a dispute. But that's not how the market works when they dispute validity. In our submission, it's actually comparing apples and oranges. It is perfectly true that in many cases, people choose to settle disputes. But that doesn't follow that where parties are at odds, and one, for instance, is saying, I don't accept. For instance, one imagines a situation where somebody says, I want to assume a situation where you have a situation where somebody says, I accept you have got a valid UK portfolio of patents for 4G, and I want to license those. And the other side say, oh yeah, but I've got patents in China as well. And the implementer says, well, I don't think any of those are valid, and insofar as they're valid, I don't think any of them are essential. But I am prepared to pay you for the English ones. Now, in our submission, there's nothing, as it were, unreasonable about that, or you can't tell it's unreasonable unless you know whether or not he is right in the...
But that assumes that the test for whether or not you get an injunction is whether the implementer is behaving in that sort of way unreasonably or not. But if the test is in fact based upon whether the patentee has offered a FRAND license in accordance with its ETSI obligation, and if it has, then whether the implementer has accepted it or not, how do you work in that sort of, well, one rule if it's contentious and another rule if it's not, into your understanding of what the ETSI license requires, which as I read it, but I may be wrong, appears to apply across the board and indeed to be designed as much as anything else to avoid litigation as to promote it?
In my submission, that's the ETSI undertaking isn't designed to deal with this type of dispute. It's actually not focusing on portfolio of rights at all. That's a fundamental point, I would say. It's actually looking at particular SEPs, and it's an undertaking in respect of SEPs.
You mean it works SEP by SEP?
Well, the result of ETSI is the undertaking is in relation to particular SEPs. But it can work on a country-by-country basis, because when you bring a dispute before a court, the court has jurisdiction to consider the position as a whole. What the court isn't in a position to do is to adjudicate on validity of the foreign SEPs.
The way you put it just now was saying the implementer may be reasonable in saying, well, I'd be willing to take a license in relation to the particular jurisdiction, the UK. But I thought that the Court of Appeal said that the true focus, so far as the ETSI undertaking is concerned, is on whether the patentee is offering terms which comply with its obligation under the ETSI undertaking to allow a license on FRAND terms. So if it may be that one could say that the implementer is acting reasonably from its point of view, but if the patentee is acting reasonably from its point of view, for all sorts of commercial reasons that were gone into at the trial, in saying, we'll grant a license, but on global terms, I mean, the Court of Appeal seemed to have said that that's the relevant test.
In our submission, that's part of the flaw in the Court of Appeal's reasoning, that you're simply saying, because if you, in a situation where, I mean, the result of what your Lordship has put to me and of the Court of Appeal's approach is a patent owner, such as these parties, can always say, well, I say I've got patents all over the place, and simply because I can establish one in any jurisdiction, that is sufficient to give me leverage to say you've got to enter into a license for all of them, however weak the rights may be, because you never get to test them, at least before you have to pay the royalty. In our submission, that would really be quite a remarkable view of what ETSI was intending. In our submission, there's nothing in ETSI to suggest that what was intended was that you would be entitled to require licensing of what may not be essential SEPs as part of a license of essential SEPs. That's what we say it comes down to.
So it's your case, I think, therefore, that the evidence which was presented to the judge about how portfolio licenses were actually negotiated between willing parties wasn't really responsive to the ETSI undertaking or similar undertaking in other standards-setting organisations, which I assume there must be, but we're just looking at the ETSI one.
Yeah, there's a whole.
Rather, it was a purely commercial process which really had nothing really to do with the undertaking at all.
Yes.
Was that a point put to the judge when he treated that evidence as relevant to the grant or refusal of a FRAND ETSI licence?
Well, the point that was put to the judge was that he should only be looking at it on a UK basis. Reference to the UK portfolio.
And that's slightly different from actual sets one by one.
The argument before the judge was country by country, but the basis on which you get to country by country, how is the court able, how do you go from set by set, is that the individual court, so if one takes the patent court here, has jurisdiction to try as many sets as are considered relevant. The parties may say, well, I'll agree, once you've tried 5, we'll settle or agree that you have a portfolio in this number. Or if the parties don't, then the court has to, under its case management powers, determine how many there are and try the issue. There are obviously different ways in which you would try it if there are very many of them.
Practical question.
Yeah.
If it is acceptable in certain cases to have a global look at the picture and try to agree a global rate, I can see that it might depend on the strength of the portfolio, how iffy the patents which are not being adjudicated upon in those proceedings are. Will that lead to sort of shadow trials within the proceedings where the attempt is being made to fix the global license to see what the validity of those external patents are?
What is happening in the patent court is, your ladyship is right, iffy proceedings are happening, but they don't look at validity, because you can't look at validity. That's a matter for a foreign court.
Well, I understand that, but what I'm putting to you is this, that the reasonableness of an offer may depend on the strength of the portfolio.
The difficulty is you can't, or at least
you
I
can't
would,
adjudicate it.
but you can't determine the strength of a portfolio without going into, we would say, without going into validity. And if you can't go into something like validity on a sort of half-life basis. And once you either are investigating it or you're not. Now, in fact, the English court is not in these trials investigating validity of any of the foreign patents. What it does do is look at essentiality, but only on a sort of look-sniff basis, as I understand it. But in my submission, that's entirely wrong to be seeking to conduct any sort of trial on that sort of basis. But particularly where you can't, I mean, you'll remember Mr. Justice Carr said, if Huawei were to plead that the foreign patents were invalid in conversant, he said that would be struck out, because that would be non-justiciable. So that, I mean, that's what makes, in our submission, this all quite remarkable, that the reality is that a large part of the royalty is on the premise that there are Chinese patents, or it's payable can only be payable on sales which could only command a royalty if there are Chinese patents. And if you say to the English court, I deny there are any Chinese patents, you're told you're not allowed to do that. That's not justiciable. And so you're put in a position where the court is ordering you to pay for those patents and saying you can't before me dispute it.
Yeah, but I mean, if the evidence from the expert witnesses had been that if you're actually dealing with that sort of situation, no commercial person would agree to a global license precisely because the Chinese portfolio is so doubtful, then it wouldn't be a FRAND term to insist upon covering China.
Sorry, I didn't mean to.
No, please. That was my question.
I apologise. The difficulty with the point your Lordship is putting to me is that what you're then having is evidence through experts saying, oh, well, one expert saying, for instance, you have two experts. One says, oh, this is an absolutely first-class portfolio, absolutely brilliant, they're all valid. Then you have another one who says, no, they're all duff. Now, what actually does the English court do there? In order to decide the position, it has got to actually see, you can't just say, well, I think Mr. So-and-so's a better expert. You've actually got to get to grips with the points that they're making as to why the underlying portfolio is or isn't good.
Well, that depends, doesn't it, on the evidence about how issues as to the iffiness of the portfolio are dealt with in negotiation. If what the court's seeking to do is to model a putative negotiation, it may not conclude it has to get to the bottom of every potential issue of that kind. I mean, I take your point that it can't, but the evidence before the judge appeared to be that in a consensual situation, although the parties would have technical meetings between teams of engineers, they wouldn't themselves seek to get to the bottom of all those issues and wouldn't require that some competent court did so either.
The Lordship already has my point, that in my submission, essentially that's largely addressing the wrong point.
I got that.
How people on a commercial level seek to settle things. But one also needs to be careful. There are two cases before you. So it's the Unwired Planet case and conversely. And whatever approach may have been taken in Unwired Planet to evidence and so on, of course, what we're really concerned with, particularly for the conversant case, is what is the right approach. And particularly where in conversant you see absolutely clearly the patents were in dispute, the Chinese patents.
Well, I think we have your position on this, and we'd better let you make progress.
Yeah, my Lord, I'm grateful.
Is it right, just before you do, that the UK-only settled licence, which the judge worked on as an alternative in case he was wrong about global, itself was the result of a supposedly negotiated construction that took into account the SEP nature or otherwise of patents in the same family in other countries, in the country of manufacture? I have it dimly in my mind that the UK-only patent was constructed as a matter of pricing upon a model that wasn't actually that dissimilar to the global.
Sorry, I misunderstood you.
Because it was a global model tweaked for the UK.
If you're asking how did he determine the rates, he did it by reference to starting, and that was the whole debate about a global license, and then deducing from that UK rates, and then deciding what rate should I apply when it's UK only.
Yes, but then if he had to do that, why didn't that offend against your principles of non-justiciability almost as badly?
He didn't have to do that. I mean, that was the way in which the parties were looking at it. But certainly, you didn't have to approach it in that way. You could have approached it purely by looking at a UK.
But I don't understand that either party asked him to do that.
No, well, the evidence they put forward was by reference to global rates.
Yeah. Sorry to interrupt you again, but I had to get it out at some stage.
Can I, just before then developing things further, can I just very briefly take you to the judgment in China at A11 tab 205, starting at 11613. This is the judgment of the Nanjing Intermediate People's Court of Jiangsu Province. And just to fill in what happened, this is litigation between Huawei and Conversant, and when Huawei learnt that Conversant wanted to sue it in England for an injunction excluding it from the UK market unless worldwide royalties for the Chinese patents were paid, it started these proceedings seeking declarations that the patents were invalid or otherwise not essential. And the 11 patents that Conversant put forward at the time of the jurisdiction hearing were found to be invalid or otherwise not infringed. Conversant subsequently then put forward 4 more to bring the total to 15, and of those further 4, 3 were also found to be invalid or not infringed. 1 was found to be essential with no trial yet to take place on validity. But it is important that this court should see the reaction of the Chinese court to what is happening or sought to happen in the Conversant case. If you go to 11643, see at the foot of the page, the court says that the plaintiffs, Huawei, have legally interested relationship with the licensing of patents involved. Because the defendant failed to exercise its patent rights in China through litigation, but adopted the method of requesting a foreign court to judge a global rate, it deliberately avoided the judicial review by Chinese judiciary authorities on whether the actor's implementation of Chinese patents may result in infringement, which created great uncertainty to the respective actions of the implementers and the interested parties, including the 3 plaintiffs in this case. So you see, the Chinese court considers clearly that by seeking worldwide royalties, or a determination of worldwide royalties through the English court's injunctive power, Conversant would be trying to avoid judicial review by the Chinese courts of whether the Chinese patents are being infringed or not, and to obtain worldwide royalties for them. And while we're in this, if you go to page 11665, you see on that page, in the middle of the page, at the paragraph beginning second, during the trial, the defendant proposed that when calculating the base rate, the denominator should be the total of all set families under a certain standard. In the evaluation of the number of real set families in this case, 15 patents claimed by the defendants were evaluated one by one. And then if you go to the foot of the page, meanwhile, these 15 patents were also selected by the defendants from hundreds of Chinese patents it declared to be standard essential. Normally, the quality and stability of these 15 should be higher or much higher than those of their parent portfolio. However, 8 of the 15 have been declared to be invalid by the Patent Re-Examination Board. 6 of the remaining have been determined to be non-standard essential after comparison with the standard. This result then was confirmed, and they had a portfolio below the average. And picking up a point that my Lady Black made to me, it's only when a court that is able properly to assess these matters can actually form a view, a proper view, as to whether it is an iffy portfolio. The Chinese court is in a position to do so, and it has formed the view that this is indeed a very iffy portfolio, with one surviving patent, which is subject to validity. And the important thing to note then, what is the impact of that, there only being one? This court then set a rate for the royalty, which it was done on the basis that the court assessed what is the appropriate overall royalty rate in China for SEPs on the particular standard. And then they asked, how many SEPs does this party have? The answer was they had one. So the royalty that the Chinese court found is one only. And if you go to page 11688, sorry? 11668. Thank you very much. 11668. The paragraph 4, they deal with the royalty rates, and you can see for 2G and 3G, it's 0. Single mode 4G is what they set out, 0.0255225, and then multi-mode is 0.0018. So, and these are a fraction of what is sought in these proceedings. And just to make good my point that this is done by reference to one SEP, if you go back to page 11666, they there explain how the royalty rates are determined, and what you see at the foot of the page is various calculations, but what it depends upon, one factor, is the number of patents you have. So in the penultimate paragraph, for instance, you will see in the calculation of the royalty rate, there's the number 1, and that's because they've got just one SEP.
And can you help me? The court is setting royalty rates here for on what basis?
What it's setting is it's determining that they put forward, the question was, did they actually have any entitlement to anything?
Right.
For that purpose, the question is, it was in dispute that there were any valid SEPs in China. The court then, the defendant put forward its 15 best. That's why essentially the sort of proud list. And the court came to the view 14 of those were duds. One, at the moment, has passed essentiality, and that's only because of the way it came forward. The Patent Review Board, or whatever it's called, the Patent Examination Board, hasn't had the opportunity to look at it yet.
But are the royalty rates that you've shown us, was that the Chinese court setting a FRAND rate?
It's a FRAND rate, but the FRAND rate is dependent upon the validity still to be determined.
Thank you.
And on these rates, assuming that one survives, I think the value of Conversant's Chinese portfolio, I think, has been calculated to be worth something like $9 million as opposed to some hundreds of millions of dollars. Now, in our submission, what you see happening in this case is exactly what we say should be happening, is that the Chinese court in the Conversant case should make the decisions on issues of Chinese law both as to validity and essentiality, and also what is the correct measure of the royalty. Now, my Lord, moving off from the Chinese-centric position, and just very briefly, to say that in a wider context, these cases, as your lordships will realise, are particularly important. The patent proliferation means that many parts of the world are swamped with patents, particularly in the technology field. Now, it's common ground that patents are very often invalid and not essential, and we've given figures on those. Now, what should be done about these legions of potentially relevant and valid patents is a policy choice for each country granting the patents. And obviously the monopoly is a national monopoly granted by the particular sovereign, and it's a matter for that sovereign to determine whether in fact there is a monopoly, and secondly, what its value is. Now, the decisions in this case, not only in our submission, override that, but they also have given rise to the difficulty, as these cases exemplify, which is effectively trading in these portfolios and seeking to leverage the approach of the English court in order to extract money. Mr. Justice Burst, we don't need to turn it up, but in paragraph 513 to 14 of his judgment explained Ericsson's motive in selling off what is a splinter of their portfolio. And that's what has happened. Something like 5% of Ericsson's and Nokia's portfolios are being sold off, and then these non-practicing entities seek to extract money. And in Dusseldorf, Judge Kuhn has described this process as the Wild West. And in our submission, it's not really surprising that the industry has resisted taking licenses where the demands are extremely high. But the approach that the English court has taken potentially runs the risk of distorting competition, not only in this market, but also worldwide. The reason for that is that, of course, Huawei is a major mobile manufacturer, infrastructure manufacturer, and so may well want to participate in this market. But other manufacturers, firstly, not all manufacturers necessarily do, and so they, the royalties that they will have to pay for these SEPs in China or elsewhere, if established, is likely to be very different indeed to the royalty which we see the court here awarding. And secondly, the risk of doing business in the UK may put companies off coming here. We've already seen, we've cross-referenced it in footnote 214 of our written case, that Zyxel, part of a Taiwanese group, faced with an injunction, the so-called Frand injunction, said it wasn't willing to agree a global license determined by the English court and withdrew from the UK market. Now, I should also, before coming on to develop the submissions, I'd also like to take you to the TQ Delta case in the Court of Appeal at A3 tab 65 MS 6107.
Could I have the MS number again? I'm so sorry.
I'm sorry,
Yes,
it's 6107.
6107.
And what you see from this case is that following the Unwired Planet case, there is an attempt essentially to try and export determinations of the English court. And the Court of Appeal, in fact, resisted. And if you go to paragraph 47 in the judgment of Lord Justice Floyd.
Page.
Page 6118.
Thank you.
And the question was, in this case, whether or not where the defendant, Zyxel, was I'm not going to dispute the injunction, I'm in fact not going to participate in the London market, whether the court could still go on and have a Frand trial. And that's what was sought to be done. And that paragraph 46, the judge had held, you can see Mr. Lord Justice Floyd refers to the fact that there was a real commercial dispute which he could decide. And at 48, Lord Justice Floyd explained why he didn't think that was appropriate. And we agree odd to be granting relief in aid of foreign proceedings, which weren't outstanding, and particularly the question whether foreign declared patents ought to be paid for is for the courts of foreign countries. And we also agree with him that the question of what is meant by a willing licensee is not in any sense an internationally recognized term of art. And what one can see is that a Chinese or a foreign court where the defendant is saying, I, in China, wish you to prove that these patents are valid and essential, the foreign court is unlikely to think there's anything wrong with that, in the same way that the UK court doesn't say there's anything wrong with the defendant in the UK saying, I dispute the validity of the UK SEPs. Position, in fact, in which the lower courts have got into, and this is what comes out of the Conversant case, is that if a claimant sues on a UK SEP, then that establishes jurisdiction. Having established that, then, accept your Lordship's point that one's got to review the evidence, but as a matter of jurisdiction, the court then has jurisdiction to decide the terms of a royalty across the world. Now, in our submission, the anomaly this gives rise to has arisen, that if a party is found to infringe a UK SEP and decides to stop using the standard in the UK, then the lower courts accept that only UK damages can be awarded. But if another party, my Lord Justice Briggs...
You mean for the past?
For the past.
Yeah.
So, I mean, if you take this case, if Huawei says, okay, I've breached the UK SEPs and I'm not going to, I'll accept the injunction, I'm going to withdraw from the market, then the damages for that are limited to UK rights. Mr. Justice Burst didn't say, as damages, it was appropriate to award the value of a global license, and what's more, he was right about that. There wouldn't have been any jurisdiction to it. But if one's then looking at the future, then the court says, no, not only have you got to pay a license for the future, you've got to pay back royalties for the past on a global basis. Now,
I mean, there wouldn't be jurisdiction to award damages for the value of the global license not taken by the potential licensee, would there? Because it's not the licensee that's given the FRAND undertaking. That's the patentee has given that undertaking.
Yeah, no, that's right. But the patentee is then claiming damages for infringement of his UK patent.
Yes.
And the damages for infringement of the UK patent are UK damages only.
Yes.
All we're saying is there's an odd anomaly that in terms of damages, you award UK damages, but in terms of if you grant an injunction as the price of avoiding the UK injunction, it's not that you should continue to pay going forward UK royalties, it's that you should pay worldwide royalties, both for the past and for the future. We say that's anomalous.
Can you just help? Because we're all working on the basis that it's only the licensor who is undertaking to ETSI. But there's another sentence in the ETSI document which says the above undertaking may be made subject to the condition that those who seek licenses agree to reciprocate. And I don't think I know what that means or whether this license included such a reciprocal arrangement.
So that's a very important point, if I may say so. What ETSI had in mind was that, and if one just turns the clock back and thinks what is going on with ETSI, it's establishing a standard which all mobile phone, if we take mobile phone manufacturers will operate on. So they all get the benefits, but everyone is contributing their patents. And so the theory is that each manufacturer, what he can't do is go to his opponent and say, give me a license, without at the same time giving a reciprocal license. And so all it's saying is that it's perfectly proper to say to an implementer, well, I want a license of your set or sets. But in this case, of course, none of that has any relevance because these parties are non-practicing entities. They're not manufacturing anything. They are just entities who have acquired part of Ericsson and Nokia's portfolio purely for the purpose of extracting royalty income for those patents. They wouldn't have any interest in a reciprocal arrangement. And previously, there were reciprocal arrangements with Ericsson and Nokia.
But how does that analysis of the reciprocity obligation fit with your submission that really the ETSI undertaking is just about individual SEPs looked at one by one? Because I think by definition, the reciprocal obligation is likely to affect royalties patents or SEPs in a different family from the family which is subject to the original licensor's obligation.
It's likely to, that's right. In my submission, there's nothing inconsistent with it. The fact that you recognize that the critical point is that the undertaking and the reciprocity relates to what are essential sets. So and the way in which a reciprocal undertaking is likely to operate is that Huawei say to Ericsson, I want a license for your 3G or 4G sets, and this is what I'm prepared to pay. And then Ericsson or Nokia says, well, we want a license for yours. So if your lordship is saying to me, do they operate? Are they likely to negotiate on a portfolio basis? The answer is they may well do, in the same way that parties more generally do. What that doesn't tell you is what is the position where the parties are in dispute as to whether there are any rights at all. And which court should determine where there's a dispute, what are the appropriate royalty rates.
Now, Mr. Howard, I see the time. Is that a convenient moment?
Yes.
Very well. We'll adjourn until 2 o'clock.